Hello and welcome to Newsclick. Following the gang rape of a young woman in New Delhi on December 16, 2012, the Government of India constituted the Justice Verma Commission with a mandate to examine the possibility of amendment to India's criminal laws and to provide for quicker trial and enhanced punishment for offences of a sexual assault. The three-member committee interpreted the government's mandate expansively and has delivered a comprehensive and wide-ranging report on the broad issue of sexual offences and societal responses to the same. The report was delivered to the government on the 23rd of January 2013. The report has been hailed by a large number of commentators as a landmark for the feminist movement in India and as a comprehensive and long-awaited indictment of governance systems in our country that have failed to apply the constitutional principles to the cause of gender justice and equality. On the other hand, the report has also been criticised by various people, including on the grounds that the committee exceeded its mandate, also that the report makes extremely generic and broad suggestions that are neither easily or practically implementable. While the report has been placed before a parliamentary standing committee, the government on the 8th of February passed a criminal law amendment bill or ordinance incorporating some of the recommendations of the Justice Verma Committee Report. We have with us today to discuss the Verma Committee Report and Criminal Law Amendment Act Ordinance 2013, Ayesha Kidwai, who is a member of JNU's Anti-Sexual Harassment Committee and in that capacity deposed before the Verma Committee. Thank you, Ayesha, for being with Newsclick today. Now, the Justice Verma Report was hailed by many women's groups as a watershed moment in the fight for gender equality in India. What are your thoughts on the Justice Verma Report? Was it as progressive and comprehensive as we are led to believe?
Well, I think it was actually, because for many years, for the last 25, 30 years, women's groups and people committed to equality have been arguing that the criminal law must flow from constitutional guarantees rather than a patriarchal law when women were considered a chattel coming from 1860. And our experience over the last 25 years also told us that the state was not listening to us. So the Verma Committee Report, because it attended to the voice and the experience of women and recognized that our legal system, criminal justice system totally, but also the legal framework in which the criminal justice system is ensconced, actually does not guarantee women equal rights. So in that, of course, the report was incredibly revolutionary, and for many of us, when Justice Verma read out the Bill of Rights for Women, one felt that this was the kind of slap on the face that we required for people to recognize women as citizens. Because if it's 65 years after independence, if there is a need to give women a Bill of Rights, to make it justiciable, as they say in the little preamble they have to it, shows that we have not created either state policy or a legal framework in which women are treated equal.
But don't you think that in presenting such a wide-ranging and comprehensive report, the Verma Committee actually exceeded its mandate in looking at issues beyond mere amendments to the CRPC and IPC, therefore possibly making it easier for the report to be rejected?
Well, that's actually what was wrong was the terms of reference of that committee. And when the committee was formed, let's be frank, nobody really thought that these three people would be able to deliver, because the terms of reference were just to look at aggravated sexual assault and to frame criminal laws. Whereas even on the streets and in the newspapers and in the media and in drawing rooms, actually the question had been put into a much broader context. So if that was the occasion, the rejection, that would be very foolish, because the issues were not really only about a legal framework, but a legal framework that looked at the imperfections in our entire social system. So I don't think it has been rejected for that reason. But it's true, the things that they could have done without legal amendments, that haven't been done either. So, for example, what the report should have occasioned was an immediate ban on the two-finger test for rape. That's by executive order. There's no legal framework there. Right. But notice that hasn't come. Or compulsory sex education, that hasn't come either. Yeah. So if that's the fig leaf that the government wants to use to explain why it won't do so, then it's tragic, because actually this kind of comprehensive and wide-ranging report is what we needed.
Absolutely, I couldn't agree with you more. But now, given that the Justice Verma Committee was able to complete what was clearly a massive task within a month, Do you think adequate care was taken to involve all stakeholders in the consultations? For example, was the opinion of the armed forces taken in when they were considering the AFSPA recommendations? Did they ask Khap Panchayats to come and depose before them when they were... There's an entire chapter on Khap Panchayats.
Yeah, well, I'm not actually privy to who, because I know that there was this 2-day hearings in which some of us were called to depose. But what we understood at the time of the hearing, that they had actually been consulting and meeting with a number of groups and individuals. I think that the question has to be, there was a commission. We all wrote to the commission. We said that this is what we think should be done, should not be done. The question you really have to ask is to the Khap Panchayats and the army, whether they cared enough for the rights and equality of women that they went to the Justice Verma Commission. Clearly they didn't, because they don't seem to be at all perturbed by it, that they weren't listened to. So, and they are not stakeholders in the rights of and protection of women, clearly.
In fact, I was told that various police officials did not appear before the committee despite the fact that they were requested to do so, again clearly showing the patriarchal nature of our military, our armed forces and so on.
Yeah, no, and certainly, so during the hearings we saw the people who were there, and actually no senior civil servant appeared. Their counsel came, and in fact what Justice Verma at one point said, that there was a circular, I think, on child rights or something, which the police. So people wrote to senior police officials, asked them for a copy, because they couldn't find a copy of that circular in their files. So I think what happened, I mean, this is my own conjecture, that the government really didn't believe that the Justice Verma Commission would deliver. And then by the time they wisened up to it, they realized that the best way is for all these institutions not to cooperate with the Justice Verma Commission.
I see. So, given that context, what, in your opinion, are the major highlights and drawbacks of the Justice Verma report?
I think the major highlights are that they, in terms of, they did a very nice tightrope walk on the matter of who shall be the perpetrator and how will you define the perpetrator of sexual assault and the perpetrator and the victim. So there was a division in the proceedings there, where people from sexual minorities were saying that we wanted, the perpetrator is always a man, but the victims can be gender plural, so they can be either men or women. And the women's movement was saying that rape is something which, if you take that away, if you take the women's specific nature away of sexual assault, then you're really not, you're not addressing the system that produces violence against women, which has a specific character. So I actually like what they did, is that they retained the notion of rape as something which is specific to a woman and defined sexual assault over it. I also, as from JNU, so we have the longest serving anti-sexual harassment committee. There's a government anti-sexual harassment bill that's been passed by the Lok Sabha in 27 minutes flat. And that bill we found extremely objectionable. They have attended to most of our criticism of the bill. And I think at every level, their extreme care in looking at the issues of child trafficking and actually setting up a framework where once you recognize there's a criminal or an offense happening against women or children, that to put up a legal framework that actually encodes that understanding. So that certainly, there are of course shortcomings like there's going to be in any report. So many people have felt that some sections of the IPC or the CRPC have been drafted too hastily, that on the matter of sexual harassment, they propose an alternative framework which makes actually Vishakha committees optional in institutions. And they've attended to some notions of community policing, which we are always very scared of, that the idea that the civilian will be involved in defense. So, and there are, and at every place, you could find an objection or two, but this is the first document that has actually encoded the women's rights understanding, the activist understanding of what is wrong with our society. So broadly, I mean, I think that it has to be endorsed, certainly.
I think that's a crucial point you made there. Now, moving on, as I mentioned earlier, the government has now passed an ordinance which they say incorporates 90% or thereabouts of the recommendations of the Justice Verma Committee. However, I think that they have left out quite a few crucial recommendations, such as the recommendations on criminalization of marital rape, the amendments to AFSPA, recommending sex education for children, etc. The government has also modified various other recommendations, for instance, the issue of the death penalty. Now, what are your opinions on the substance of this ordinance itself? Does this carry forward the spirit in which the Justice Verma Committee report was written?
Yeah, actually, that's a, the ordinance is a cautionary tale, actually, because, if clearly you can incorporate bits and pieces of Verma, right, and then still yield an ordinance which is actually arraigned against young people's and women's rights. So, it actually, I mean, frankly, it's a moment in the ordinance. While it recognizes stalking, it recognizes acid attack, but in every place where they've taken the Verma commissions, there is always something either in that section or just or in some other part which actually undercuts the understanding of Verma. I mean, I can go on and on, but
Could you give us an example? You were speaking about the instance.
So marital rape. I mean, marital rape is most probably going to be a provision that's not going to be used that much. But the other thing which has made a lot of us extremely angry is that they have, one, collapsed the distinction between penetrative and non-penetrative sexual assault, and which now says that the consequence of that is that even touching another person is a possibly criminal act if you are under 18. Okay. So, all under 18, which is a completely 1860 notion, that two young people at the age of under the age of 18, even if they have consensual, necking or fondling each other, on the first offense, it's 7 years to life imprisonment, and if they happen to be caught again, then it is life imprisonment to death. So, in a real way, the state has become the new Khap Panchayat. I mean, everybody and all the goons who police women and tell them what to wear and tell them to wear overcoats, all of these people have been given a huge shot in the arm by a legal system which allows now that any kind of consensual sexual activity, it's, the control of young people is something that this ordinance legitimizes. Then, of course, there is the question of marital rape, and also the fact that they have listed a penalty for army officers, but then they haven't actually removed the special sanction that is needed to prosecute them. Similarly, the Verma distinction between penetrative and non-penetrative rape sexual assault is gone. But now sexual harassment, the definition in Vishaka is now used to define, they've retained outraging the modesty, but they've also defined that section 354 like this, which means that that section is very general. So actually cops are being given an option. Either you prosecute somebody for sexual assault, or you prosecute them for sexual harassment. So there is so much overlap that the cops actually have got much more power. Much more power. And this is going to mean that many cases of sexual assault are really going to be redefined as cases of sexual harassment. And I thought that the first business of lawmaking was to clearly define what kind of act is going to fall under which provision. And so from 509 through to 375 to 354 and God knows what else, all of them cover sexual crimes. So this is a really disturbing aspect.
So quite clearly some ill thought out provisions there. But can the passing of the ordinance not be seen as a crucial first step taken by the government, and that too with minimum delay, given that it was passed in 1 week? I mean, what is wrong in first carrying out amendments to the IPC and the CRPC and leaving more complicated issues to be dealt with pursuant to more consultation? Or do you think that the entire report should have been taken up after discussing the issue in Parliament?
Yeah, if you do it in this fashion that the government has done, it's done these bit by bit modifications. And so, even where they have accepted Justice Verma, for example, they haven't taken the whole provision. So, in the case of sexual assault, it's very intriguing that the Verma Commission lists a number of crimes that fall under sexual assault and includes, let's say, clitoridectomy in it. They actually say that female mutilation of genital mutilation. The government has left it out without any explanation. So, it's, contrary to what the way your question poses it, I think a change in the law can come only when you have a holistic understanding, right, of the reason why our criminal law is like this and what is the direction in which it can change. If you break it up bit by bit, then you can get stalking, but you can allow genital mutilation. That's not so. In fact, the government didn't seek. What it's seeking to do is actually frame the debate in a particular manner. It's taking out all the patriarchal. Also, patriarchal protection is entirely intact in the ordinance, and so now we are supposed to be just debating whether these provisions in the ordinance are going to be there at all. Today, I mean, we were all shocked to see that Chidambaram wringing his hand and saying what to do, the army is not, conciliatory about AFSPA. But, I mean, is he the the finance minister of India, or is he the finance minister of Pakistan? Because, or at least what people believe is what the finance minister or the home minister of Pakistan would be saying. Because, in fact, we are a civilian government. And if the government were to change the law, then the army would have to just go with it. So, it's a malicious act, the ordinance. We also wanted that actually, because as I've said, we've had some issues with the drafting. The democratic process is something that we would want it to use that democratic process to let our parliamentarians show us that they have listened to the thousands of young people and women that were out in the streets all over India from the end of December. But actually they didn't. So by passing this ordinance, they've sought to scuttle debate rather than to promote it, and certainly to scuttle change.
Now, given that, as you've mentioned, the government itself is a patriarchal system, what do you see happening next? I mean, and what would you, as a member of a women's group, look to do to bring about change in the law as it stands?
Well, we've been set back. I mean, there is no doubt about it. But that only we've been fighting for 30 years, and we will continue to fight. And so, our first call must be that, there was a standing committee that was looking into the criminal law amendment bill. And we wanted to ask parliamentarians that the rights of parliament have been taken away by this ordinance. So now they should not let this, they should reject this ordinance rather than letting it lapse. And in that debate, we seek to intervene so that the Justice Verma Committee recommendations and our, wherever there are reformulations of it, that our parliamentarians must show us that they care about the rights and equality of women. So our goal will be to, of course, lobby with parliamentarians. And if we do not succeed, well, really, we will continue. We've been on the streets since December 16. And just like we got the Justice Verma Commission, we are going to get the laws that are needed.
We wish you luck, Ayesha. Unfortunately, that's all the time we have for today on Newsclick. Thank you, Ayesha, for being with us, and thank you for watching.